Can student loan debt be discharged through bankruptcy if the debtor committed fraud? If you are wondering about the intersection of student loan debt and bankruptcy, especially in cases involving fraud, you are not alone. This topic can be quite confusing, but understanding the basics can help clarify things. Student loans are generally tough to discharge in bankruptcy. Most of the time, they can only be discharged if the borrower proves undue hardship. This is done through a legal process called an adversary proceeding, which can be quite involved. Now, when fraud is part of the picture, things get even trickier. Fraud in bankruptcy means that the debtor has intentionally deceived the system. This could involve providing false information or hiding assets. If fraud is proven, it can lead to the denial of discharge for the debts, including student loans. For example, if someone committed fraud to get a student loan, like lying about their income or eligibility, that loan may not be dischargeable. Courts may refuse to discharge student loans if they were obtained through dishonest means. Fraudulent actions can include forging signatures or misrepresenting eligibility. There are specific cases where student loans can be discharged due to fraud. One of these is called false certification discharge. This applies if a borrower was wrongly certified as eligible for the loan, like not having a high school diploma or general educational development certificate when they enrolled. Another situation is forgery discharge, which occurs if someone else used the borrower's identity to take out loans without their knowledge. To pursue these discharges, the borrower must provide evidence and apply through the appropriate legal channels. Even if fraud is involved, the borrower still needs to follow the legal procedures to seek discharge of their student loans. This often means gathering detailed documentation and possibly attending court hearings. The Department of Justice and the Department of Education have processes to evaluate claims of undue hardship, but fraud complicates these cases. If fraud is proven, the court may deny the discharge of the student loan debt or even the entire bankruptcy discharge. However, if the debtor is a victim of fraud, such as identity theft, bankruptcy may provide a way to discharge those loans. It's important to note that there is a lot of confusion around student loan dischargeability. Some private loans may be dischargeable if they do not meet the strict definition of qualified education loans. Some borrowers have successfully discharged private student loans in bankruptcy when fraud was involved. However, courts take fraud allegations very seriously, and discharge is not guaranteed. In summary, committing fraud related to student loans generally makes it harder to discharge those loans through bankruptcy. If the debtor is a victim of fraud or misrepresentation, there may be options available for discharge. Navigating the bankruptcy process requires careful attention to detail, especially when fraud is a factor.